Good afternoon, everyone, and thank you for joining us for today's webinar, which will address the medical and legal aspects of family conflict with the medical team at End of Life. My name is Deanna Fenton, Program Manager here at the Alliance, and as always, it's my pleasure to welcome you to today's program. Now, before we go ahead and get started, there are a few housekeeping items that I'd like to take some time to review. To ensure an optimal visual and audio experience, it is highly recommended that you access our webinars using the Chrome browser. If you're already using Chrome and experience any audio issues, we do recommend reconnecting to the webinar using the phone number that was provided in your confirmation email. Now, to those of you who are joining us for the very first time today, please take note of the chat feature that's located in the bottom left-hand corner of your screen. This chat will be used to pose your questions to our speakers. So if you have any questions that come up during the course of the webinar, please feel free to submit them at any time. Once the presentation has concluded, we will transition into our Q&A discussion where our presenters will address as many of your questions as time allows. Now, for those of you interested in our upcoming webinars, registration is currently open for our upcoming webinar on Transplant Peer Mentors, a new approach to enhancing the patient experience. Be sure to join us for that on February 27th at 3 p.m. Eastern. Registration is also open for our next Get Connected webinar on Donation Champions, Strategies for Developing Advocates Inside and Outside of the Hospital. That's coming your way on March 10th at 2 p.m. Eastern. For more information on all of our upcoming webinar offerings or to register, please visit our website at organdonationalliance.org. For those of you seeking continuing education credits, we are offering one CEP-C credit and one nursing contact hour for this webinar. Please note we do also offer a certificate of attendance for anyone seeking CEs that are not available. Everyone joining us today is eligible to claim either of these credits or certificates, but prior to receiving your certificate, you'll be asked to complete a brief online evaluation that will allow you the time to provide us with your valuable feedback. If you're listening in a group, please be sure to get the evaluation email from your group lead. As a friendly reminder, you'll have 30 calendar days to complete your evaluations and claim your credit. Now, at this point in time, I'd like to introduce our moderator for today's webinar, Ann Willingham, Donation System Specialist at LifeGift. And thank you so much for joining us today to facilitate today's presentation. I'll go ahead and turn it over to you to introduce our speakers.
Thank you, Deanna. As Deanna mentioned, today we'll be discussing the medical and legal aspects of family conflict with the medical team at End of Life. The transition from medical treatment to end-of-life care can be challenging and often met with resistance by families. This webinar will focus on particular challenges that the medical team faces when a family does not want testing carried out to make determination of death, or they do not want determination of medical support after declaration of death. We will also focus on religious beliefs legislation regarding deaths in the healthcare setting. It's my honor today to introduce our two presenters, Dr. Thomas Nakagawa and Alexandra Glazier. Dr. Thomas Nakagawa is a pediatric critical care specialist and professor of pediatrics at the University of Florida College of Medicine, medical director of the Pediatric Intensive Care Unit at Wolfson Children's Hospital in Jacksonville, Florida, and continues to serve as the assistant medical director for Carolina Donor Services in Durham, North Carolina. He is a well-renowned national and international speaker and has lectured extensively, providing more than 275 lectures in 14 countries. He's been recognized regionally and nationally for his leadership and involvement with ethical issues, end-of-life care, donation and transplantation, determination of death, and his work in the field of pediatric medicine. Dr. Nakagawa serves as a consultant for issues pertaining to pediatric organ and tissue donation, as well as donation after neurological death and circulatory determination of death. He has authored numerous articles and book chapters, including pediatric donor management and dosing guidelines utilized by organ procurement organizations nationally. Dr. Nakagawa co-chaired the Organ Donation and Transplantation Alliance Donor Management Task Force Committee and currently serves on the board of directors for the Organ Donation and Transplantation Alliance as the Society of Critical Care Medical Liaison. Our co-presenter today is Alexandra Glazier. Alexandra Glazier is president and CEO of New England Donor Services, an affiliation between two OPOs, the New England Organ Bank and LifeChoice. New England Donor Services serves to integrate clinical operations, staff, and leadership of the two OPOs with the goals of increasing donation in the region and deriving financial efficiency. Prior to her current role, Alex was CEO of New England Organ Bank, where she developed a vision for an affiliation with Life Choice and negotiated the creation of New England Organ Bank. Accomplishments under her leadership include coordination of over 1,000 organ transplants, the first HIV-positive organ donation for transplant under the HOPE Act, and the first GUBCA transplant in the United States. Alex currently serves on the OPT and UNOS Board of Directors and previously chaired the Ethics Committee and held a 6-year appointment on the U.S. Secretary of Health and Human Services Advisory Committee on Organ Transplantation. She's worked to address regulatory barriers to conducting clinical trials and presented on this topic to the Institute of Medicine. Alex is the chair of the Legislative Committee for AOPO and a consultant to Donate Life America, including her work on the recent Apple venture. Alex was previously New England Organ Bank's Vice President and General Counsel and practiced health law. She holds an undergraduate degree in bioethics from Brown University and a JD MPH from Boston University, where she served as faculty. At this time, it's my pleasure to turn the presentation over to Dr. Nakagawa and Alex.
Well, good afternoon, everyone. Actually, probably good morning to some of you on the West Coast. And welcome to all who are participating in this webinar. In case you haven't guessed, I'm Tom Nakagawa. I'm not Alex Glazier, but I am joined by my esteemed colleague Alex Glazier today from New England Donor Services. I do want to thank the Alliance for our kind introductions and allowing Alex and I to present this webinar on medical and legal aspects when families disagree with the medical team at end of life. As with any CME activity, the authors have nothing to disclose regarding conflicts of interest related to this presentation. There's been a rash of recent high-profile cases that have surfaced in mainstream media about families disagreeing with the medical team about brain death and refusing to have medical therapy stopped or have testing done to determine neurologic death. These cases have involved children and adults. They've occurred not only in the United States but also in Canada and the United Kingdom, where families have sought the assistance of the legal system. And at the core of these cases is really a fundamental question about, one, who makes the determination of death? Is it the courts? Is it the families? Is it the physicians? And the second issue is really, are these cases about how we determine death or how we define death? And as we really delve into this, I think that this is a symptom of a much greater problem within our medical community. And this is when families disagree with a medical team. And these conflicts exist because of religious and personal beliefs that can impact things such as transfusion of blood products, for instance, vaccinations to prevent diseases as evidenced by the recent measles epidemic, and even parents who disagree with treatment of cancer and choose to avoid potential curative therapy for an unproven holistic approach to treat their child's cancer. Now, the issues related to brain death and families who disagree with the medical team are really at the far end of this spectrum. But it's important to recognize this because it can have significant impact on the medical community on multiple levels. So the objectives of the webinar that we're presenting today are really to provide you with information about the medical and legal consideration when families disagree with the medical team at end of life, including determination of death by neurologic criteria. And the key objectives will include issues related to the ethical, legal, and the medical challenges that we face when these situations arise. When a family doesn't want specific tests performed to make a determination of death, when the family does not agree with termination of medical support after declaration of death, state accommodations regarding determination of neurologic death, and strategies to help families and also the medical team when these disagreements occur. So as we start this webinar, an important question that we really need to address at the center of this controversy is the primary issue that we're dealing with. Is it defining death, determining death, or both? And so to really help us better understand this issue, we're going to talk about this, and I'm going to turn the slide deck over to Alex to talk about defining death.
Great, thanks, Tom. And so the question of, is the primary issue defining death, determining death, or both? You know, the answer is yes, meaning it can be either, and in some instances, in some cases, it's really been both. But to step back a little bit and set the context for how we think about defining death in the law and how we consider determining it as a medical standard, we start really with the Uniform Determination of Death Act. And this is a model statute that was developed in 1981. It was on the heels of the Uniform Anatomical Gift Act, which all of us in the donation community are quite familiar with. And at the time in 1981, it became clear that there was really a need for a uniform definition and a path for determination of death, that this was identified as vital to ensure that there was some consistency, both as a legal matter but also as a medical standard for pronouncing death, and all the numerous legal consequences that follow from that. So, of course, organ donation being the one that we work with on a daily basis, but a number of other legal consequences flow from the pronouncement of death. A will go into effect. There are taxes that will be implicated, and also resource allocation, that we wouldn't expend medical therapies on individuals that have died. And so for all of those reasons, the Uniform Commissioners, the same group that developed the Uniform Anatomical Gift Act, drafted the Uniform Determination of Death Act. And what that statute did was set a clear legal standard for defining death. And in fact, what the statute says is that an individual has died when all functions of the entire brain, including the brain stem, or circulatory and respiratory functions have ceased, and uses the irreversible standard right in the law. And so there must be an irreversible cessation of either those neurologic functions or those circulatory and respiratory functions. And so with that, the law created this definition of death, and what the UDDA said was that the diagnosis to that legal standard would need to be done in accordance with, quote, medical standards. And while that seems relatively ambiguous, it's actually, from a lawyer's perspective, not that unusual, because in general, medical standards aren't legislated, as they're considered the practice of medicine and acknowledgement that they are dynamic and change over time. And so this deference to accepted medical standards was put right into the UDDA. But what that meant is that how death is determined as a matter of a medical diagnosis is not really defined in the law. And therefore, as we move through some of these more complicated cases, they're open to more interpretation than the legal standard itself, which is relatively specific. And I might add, from an international comparative perspective, the U.S. law under the Uniform Determination of Death Act is actually fairly precise as compared to what you see in other countries, where there really isn't clarity to the point of things like irreversibility or the two criteria being spelled out, meaning either neurologic function or circulatory sensation. So with that, we have an understanding of how the law looks at defining death, but that determination component, I'm going to hand back to Tom to describe what this means from the clinical perspective.
So building on what Alex has already talked about, let's talk about the determination of death. And the first thing that we need to understand about death is an event. It's a point in time during the dying process. And we have to remember that dying is a process and death is an event. And the determination of death really indicates an irreversible point in the dying process, not that the dying process has ended. Determination of death doesn't guarantee that all bodily functions and cellular activity, including that of every brain cell, is ceased. Circulation, we know, can be maintained for hours or days to enable recovery of organs for transplantation. So we can support these organs, if you will, somatic support, but it doesn't necessarily mean the patient is alive. It means that we are supporting organ function. Now this is where understanding terminology becomes important, because function is what the organ is supposed to do. And that's the key when we talk about the UDDA. It talks about the function of the brain. The function, for instance, kidneys filter waste. Liver produces coagulation factors and detoxifies impurities in our bloodstream. In the brain, the function of the brain is allows us to comprehend, to be conscious of our surroundings. That's different from organ activity. Now, organ activity is the physiologic response of the cells that make up the organ. So the cells have to work together to provide overall function of the organ. Let's see if I can help you better understand this. Let's look at the secretion of antidiuretic hormone in the brain. It's really a physiologic response. It's a bunch of cells that are working together to provide a physiologic response. If we look at the heart, those cells have to work together to provide overall function. And the function of the heart is cardiac contraction to produce circulation, which is the function. Now, the cells can work independently with no resultant function of the organ as a whole. If we look at the pituitary, it can secrete antidiuretic hormone, but that doesn't necessarily mean the brain is not dead. Lack of pituitary function is not a criteria for brain death. Even though the pituitary may secrete antidiuretic hormone, that's a physiologic response to a bunch of cells that are working. It doesn't mean the brain is functioning. It's just a collection of cells that brings about a physiologic response. The same could be said of the heart. Function is the contraction of the ventricles that brings about anterograde circulation that results in forward flow of blood, leaving the ventricle going out to the systemic circulation. Now, a heart that is fibrillating is not functioning, but the cells are still working. They're not working together, but it's a collection of cells that's no longer allowing the organ to function as it's supposed to. So the heart can't perform its primary function, which is circulation of blood. So function and organ activity are two different things. Importantly, when we look at this, there's no clinical or imaging study that can actually establish that every cell in the body or in the brain has died. We don't have that technology available to us. The determination of death, whether it's circulatory or neurologic, really serves as a clinical endpoint where our medical treatments no longer sustain life and the limits of our accepted medical practice have been reached. And that's really where we are with all this. Now, how do we actually make the determination of death? Well, we actually have guidelines that allow us to make a determination of neurologic death. And there's two national guidelines that are currently available. One for adults from the American Academy of Neurology and one for children from the Society of Critical Care Medicine, American Academy of Pediatrics, and the Child Neurology Society. And both these guidelines have been published within the past 10 years. Importantly, they've been extensively reviewed and endorsed by multiple medical organizations, and these guidelines are the accepted medical standards regarding how clinicians make a determination of neurologic death. Now, the guidelines are important because they really do help standardize the professional to determine neurologic death in children and adults. And importantly, the guidelines provide us with the minimum criteria. And I want to emphasize that it's the minimum criteria. If you can't meet this basic minimum criteria, then we've got a problem in trying to determine neurologic death. The guidelines don't challenge the definition of death. They only define how death should be determined. And in many of the high-profile cases, the definition of death is being questioned by families who refuse to accept or reject determination of death based on currently accepted medical criteria. But there have been cases where determination of death has also been challenged. And Alex, I didn't know if you had any additional thoughts on that.
Yeah, I mean, that's correct. So I think most of the high-profile cases start out with a challenge to how death has been determined, and so that's where things like these guidelines really do come into play because, as I mentioned before, the legal standard imports accepted medical standards as part of the legal standard. So to the extent that you can point to societal guidelines and these minimal clinical standards and show that they've been followed, then that's how you fulfill the legal criteria that death has been determined in accordance with accepted medical practice. And so then in those cases, sometimes the argument moves from how death has been determined, how the diagnosis was made, to whether the legal standard is legitimate to begin with. And I think that those arguments are harder to make because the law is relatively clear, but the touch points, that get focused on are things like irreversibility. And so at what point are these diagnostic tools accurately showing irreversibility, and what does it mean for entire, cessation of the entire brain versus, as you mentioned before, Tom, components of it. And so I think that this again kind of loops back to the fact that there can be conflict both in how the determination is made and even ultimately on how death is defined. But that said, I think the law plays an important role in trying to keep the conflict focused. And so just move into the next slide. There we go. I think, essentially what we're trying to say is despite all these attempts at clarity, both through the Uniform Determination of Death Act and also through clinical guidelines that have been developed nationally, we know that families don't always agree with the diagnosis or even the legal standard. And so in those instances, we're presented with, complex conflicts that have aspects of medical, ethical, and certainly legal considerations. The place to start with all of this is, what does the law say? And, because, and many people have heard me say this before, in general, the law is a floor and never a ceiling on how we approach conflict or human decisions or concerns, but we do want to make sure that we meet that floor, the threshold requirements, and know what the law has to say. And so every state has the UDDA standard in law. Some that's been either through statute, in some states it's through case law, but the standard exists in every state in the U.S. We also know that some states have specific provisions in their brain death law or in their Uniform Determination of Death Act that provide an accommodation from declaration based on neurologic criteria, brain death criteria, and those accommodations are usually based on there being a sincerely held religious belief and provide for some period of time to accommodate that belief. The 4 states that I'm aware of that have such an accommodation are New York, New Jersey, California, and Illinois. And of those, really only New Jersey has an exception to the UDDA standard, and I'll get into that in a second. The other 3 have this provision within the UDDA that there needs to be an accommodation for some period of time if there is a belief or a concern regarding death declared by neurologic criteria. And so, for example, in the California statute, or it's the code, what the law says is that there needs to be this accommodation for a reasonable, quote, period of time, and what is reasonable can consider the needs of other patients and prospective patients that may be requiring urgent care. And so in that sense, there's some acknowledgement that resources are, and consideration of use of resource is a reasonable thing when determining how long an accommodation needs to be made when declaring death by neurologic criteria. Now, in comparison, New Jersey has an actual exception built right into its statute. It's an exemption from declaration. It in fact specifically says that the death of an individual shall not be declared on the basis of neurologic criteria if there's reason to believe that the individual's personal religious beliefs are such that the declaration would violate those beliefs. And that's a quote right from the New Jersey statute. So this is really different than the other two, which have generally been interpreted to mean, okay, so the hospital needs to give the family reasonable time. That's generally been considered maybe 24 to 72 hours. In comparison, the New Jersey statute is actually providing an exemption from declaration on the basis of a religious objection. There was an interesting article in 2018 that did a survey trying to get at how frequently this actually occurs in New Jersey. And this article, I think it was published in the Journal of Bioethics, looked at a 5-year period. It did it through a survey, and it found that there had been approximately 30 to 35 exemptions claimed in New Jersey based on that provision that I just mentioned. That represented about 4 to 5% of all deaths declared by neurologic criteria. So while the article concluded this is a really small number, I would say that it's small, but it's not zero, and could certainly have an impact on our work as organ donation professionals. So it's an interesting point. Other states have not followed suit with New Jersey. And in fact, most courts who have weighed in on this issue have determined that once death has been declared in accordance with the law and medical standards, there really is no continuing right to, quote, therapy for a decedent. And this is included even in the McMath case in California. So there are really very significant consequences to the declaration and a judicial recognition that once that declaration has been made appropriately, that resource doesn't need to continue, even if it has to be accommodated for some short period of time. So when families deny the performance of the medical tests to even make that determination, then we really find ourselves, or the care team finds themselves, in a difficult position. It raises a question of whether we need permission to do diagnostic testing. Do the families have to agree to this in the first place? And the law has never held that consent is required for a diagnosis. Okay, we don't ask permission to make a diagnosis. But I think the implementation of testing can be somewhat of a gray area, and that's exactly where then these conflicts can open up. That generally diagnostic tests don't require specific consent in these circumstances, but arguments have been made, and there have been different court opinions on that piece. In most of the high-profile cases, the testing has already been completed at the time that the family raises an objection, because it's really only after that diagnosis is made that the family objects to it, versus objecting to the testing to make the determination in the first instance. But it's an interesting distinction, and again, the law views the diagnostic component very clearly, whereas the testing piece is a little bit less certain. So with that, Tom, I'm going to hand it back over to you to talk about what does this mean for the care team.
Sure. And just going back one slide here, Alex, an important point is that, medical judgment occurs, and when we're making medical decisions, we have to make a judgment about things. And in this particular case, medical judgment occurs when the physician has to make a decision about when to initiate testing for neurologic death. But actually determining neurologic death isn't a medical judgment, because we've got specific guidelines that outline that process for physicians to make a determination of neurologic death. And the determination of death occurs when the patient meets all those criteria based upon our currently accepted guidelines. Now, I think that one of the reasons that families begin to deny these tests is because, one, they may seek legal counsel sooner than later, and they know that once a patient is determined dead, they're a decedent and no further treatment will occur because the physician-patient relationship has ended. And so there's no obligation of the medical team to continue to treat that particular decedent unless organ donation is planned. Now, that leads us really to what happens when families deny performance of medical tests to determine neurologic death. And we need to understand that the patient and the family are putting their trust in the physician as a professional. They're trusting that the physician is going to use their skills, knowledge, and talents to assist and promote the interest of the patient. But what happens and what are the effects on the medical team when the family doesn't agree with the assessment or believes the medical plans are not in the best interest of the patient, or that the plans don't even align with what the family believes or wishes for their loved one? And this really can lead to some ethical and moral consequences for the medical team. And if this patient has already been declared dead, then we're dealing with the decedent and we're maintaining somatic support for this body, if you will. And then the question becomes, do we have to do daily rounds? Do we have to chart vital signs? Do we have to get laboratory studies or radiographic studies? And if we do get these studies, do we make treatment decisions based upon those laboratory and radiographic studies for a decedent? There's the moral distress that goes along with that. There's financial considerations that go along with that, and there's appropriate utilization of resources that have to be considered because we have other critically ill and injured patients that may require our services as intensive care units. And so I think that it's important to recognize that this has a profound effect upon the medical team. And as we look at this, I want to now turn our attention to better understanding why families may disagree with the medical team and maybe some strategies to help the medical team when this disagreement occurs. So, strategies with the family to help the family and the medical team when we reach this juncture and we're in disagreement.
Yeah, I mean, and so we start with, how did the families come to this place of disagreement and conflict? And in many of these cases, there's an underlying and profound lack of trust in the medical system in general, or maybe more specifically in the particular hospital or care provider in that instance. So, for example, in the McMath case from California, there was the potential for significant medical malpractice claim related to the care that resulted in Jahai McMath's eventual death by neurologic criteria. And that's not unusual. Many of these cases have medical misadventure at the beginning of them, and so understandably the families are coming to this moment with the declaration already mistrusting the medical system, the providers that they have been working with, and that sets up a very difficult dynamic and potentially one where families perceive a conflict of interest as between the care provider and themselves. And I think, more generally, and certainly as donation professionals, we see this frequently, the perception about death is challenged in these instances. These are cases where the patient is warm to the touch, their heart is beating, and really don't look deceased in the way that the general public understands that term to mean. And so those combination of factors can set up a context where the conflict can arise. And then, Tom, if you were going to discuss a little bit about how the news feeds into this and builds upon that type of conflict.
So, it's interesting how we get information today compared to even 10 or 20 years ago, because families now turn to social media and the internet to gain information and learn about medical issues. And there's online support groups that empower patients and families to question medical decision making that can ultimately affect patient care, and it can have a significant impact on the medical staff as well. Patients seek information and they ask questions to make suggestions regarding medical treatment. And this is where we get into family-centered care, which includes the family in the decision-making process. But this is vastly different from what I term family-directed care, where the family many times has limited knowledge of treatments or how treatments may affect the outcome, but they demand certain tests or medications be administered. And in some cases, they actually prevent certain tests from being performed or certain medications from being administered. Now, unfortunately, believe it or not, the internet isn't the greatest source for medical information. But the internet really has changed the dynamic of our medical practice because there is so much inaccurate information that's commonly received by the public through social media. And while some of that information is reputable, the public really may have confusion about what is fact and what is fiction. And then let's compound this a little bit more with the Hollywood School of Medicine, which provides us with additional medical information from people who have gone to the Hollywood School of Medicine, and that leads to further confusion for parents and families. Now, there's an interesting publication in CHEST 2018. The authors were Jones and October, and they actually looked at the top 10 Google internet sites and the YouTube sites for brain death. And their study revealed a significant amount of inaccurate information about brain death affecting the public's understanding of the concept of brain death, and also resulting in a very negative emotion, specifically towards physicians, and the link between brain death and organ donation, of which organ donation and brain death were linked in the majority of these top 10 sites. Now, much of the information that they looked at in these top 10 sites from YouTube and also Google were personal statements about a loved one recovering from brain death. The top site was actually a parody on brain death, believe it or not. And so the cyberspace parody often has information that's fabricated or it's just plain wrong, and it's very difficult or sometimes impossible for the public to sort that out. And it's important for us to understand that this doesn't happen just with brain death. It also happens with many other disease processes. And so we need to understand where the public is getting that information so that we can share with them where we as medical professionals get our information. Additionally, I think many of the websites contain a lot of negative information about donation, and it stems from the emotions tied to the discussions about brain death and the loss of the loved one. And this leads us to the final point on this slide, which is the communication between the family and the medical team. And I think that how we communicate with families becomes very important. We really need to be consistent from everybody talking with a family, because we have all this terminology that we use, but the terminology becomes confusing. For instance, the term brain death. It's a medical term. We use that all the time. It's just like subarachnoid hemorrhage, myocardial infarction. Those are medical terms. We need to try and break that down for the family into very simple terms. Brain death actually as a term really describes the death of an organ. And what I would emphasize to you is that we should really utilize terminology that describes the death of the individual, because death isn't about the death of an organ, it's about the death of a person. And that's why phrasing such as, your loved one has suffered a severe injury to the brain that's not recoverable and your loved one has died is a much better way than trying to say your loved one has died of brain death. You never hear somebody walk out and say, I'm sorry, your loved one died of cardiac death after you've done 30 minutes of CPR. The term life support, we read and we hear about that all the time in the context of brain death, but we're not supporting life because death has been declared. And importantly, we need to avoid providing options for families. And this commonly occurs after a patient has been declared dead, and the family asks, well, now that our loved one has died, what is next? And the doctor or whoever says, well, we need to discuss stopping medical therapies. Well, we need to discuss as an option, and given the option, most families will say, I don't want you to stop medical therapies. So if you give them a choice, they're probably going to take that choice. And there are no choices once somebody has died. Medical therapies stop because they can't help your loved one. They've died. Families really need to understand, and we need to help them understand, that the best possible outcome many times is different from the most likely outcome. And I think in these situations, a lot of times things are moving at such a fast pace, things are out of control, and connecting and being empathetic with a family are really important, because the patients and families want to know that you care about them and that you appreciate the pain and the difficult circumstances they're going through. And if it means giving them another 12 hours to kind of sort through this and having more conversations, it's probably something that we need to do. So that brings us into the next portion of our talk today, which is reducing the legal conflict.
Yeah, thanks, Tom. And I think, recognition right up front that the title of this slide is Reducing a Legal Conflict. There's really no way to completely avoid a legal conflict in some of these cases. But we know that there's steps we can take to make the legal controversy not the focus of what needs to be resolved with the family. because if we can remove some of these legal components, then we can focus on the human side, as Tom said, and try and come to some path forward that's acceptable for all and supports the family in the situation that they're going through, and is respectful as well of the resources and time of the care team. So, one way to start thinking about how to address a legal conflict well in advance of before one arises is to make sure that the laws themselves are clear and that hospital policies are not only consistent with the law but as clear and specific as possible. And along with those hospital policies needs to be the training that hospitals are going to actually follow them, because as many people are aware, having standards and policies are helpful when they're followed. They're definitely not helpful when they're not followed. And so you want to make sure that in advance of any cases like this, that there's been a review. What is the state legal standard? How is that reflected in the hospital policies? And what's the protocol to follow in these circumstances? And we'll get to the escalation and de-escalation protocols in a moment. And so another component of this is how do you address the medical standards, and again, as a key piece of the legal requirement, being that acceptable medical standards have been used in making the determination of death. One of the ways to address this when the cases occur is to make sure that there is an opportunity, ideally for an independent second opinion or multiple second opinions. In part, this removes any appearance of a conflict of interest, or, as I mentioned in prior slides, if the family is coming to this circumstance or the case with a mistrust of the medical system, or maybe even specifically a mistrust of the providers in this particular instance, because there could be underlying medical malpractice, then having that independent second opinion is really key, and also helps reduce the legal conflict by providing additional support that accepted medical standards have been followed in making the declaration to begin with. The other thing I would note is that utilizing a death certificate versus relying on a brain death note is a really important way to help reduce the legal conflict. And that is because death certificates are widely understood by courts. They're understood by the public. They're understood by the media, whereas brain death notes, kind of similar to how we describe death, is death. A death certificate is clear, whereas a brain death note seems to implicate that it's something other than a death certificate. And so having the death certificate completed as a conflict is arising can be helpful. That was done in some of the high-profile cases like McMath, so that alone is not going to eliminate the legal conflict, but it does make the discussions in the court context and in the public simpler. And then court is really a last resort. I mean, as care providers, you don't want to see a relationship with the patient or patient's family turn into an adversarial one, which is what happens when somebody goes to court. That said, the introduction of lawyers into conflicts like this are not necessarily a bad thing. I have seen cases where a family, upon obtaining a lawyer, actually moves towards a more reasonable path given the specifics of the law. And so I never discourage families or providers from seeking their own counsel when there's questions like this, because I think more often than not it's helpful. But court itself ought to be a last resort. And it's usually instances in these cases where the family would go to court and ask for a temporary restraining order, preventing the hospital or care providers from eliminating the ventilator support or other support, that somatic support that is keeping the body going. And there are ways to negotiate that timing, of course, without going to court, and providing that timing as an accommodation, even if it's not required by statute, can really help de-escalate a situation, slow everything down, make sure the questions are answered. I think the experience of rush is not a good one in terms of reducing the legal conflict. And in a circumstance where a patient has been declared, then there isn't a need to be precipitous, and I think that can be one of the helpful strategies.
So how do we help families better understand these situations? And I think the first thing that we need to understand is these families are really in crisis. And it's important for us to understand and remember that these families are in a situation where they have no control. All of us are used to being in control of our loved ones, in control of our lives, and they don't have a say-so. This is just happening very quickly, and the families may feel the entire process is rushed, and as I've already stated, and Alex has stated the same thing, giving them a little bit more time and more conversation to help them understand that their loved one will not survive or has died can be beneficial. Now, that being said, I think that the obligations of the medical team are really to make sure that the families understand this, and the time to be mentioning death is not when you're doing brain death testing. Death really needs to be mentioned as a potential outcome from any life-threatening injury when a patient is admitted to the ICU, and this conversation really starts when the patient is admitted to the ICU, not when you're starting to do brain death testing. And this is important because it prepares the family for a less than ideal outcome, a less favorable outcome, and it allows them time to begin that preparation, the psychological preparation. We've talked a little bit about the second opinion. Second opinions are always good, and in many cases, these are opinions sought from medical experts within your own institution, or perhaps in your own city. And in many institutions and states across the United States, a second brain death examination is required. I will tell you that in many of the high-profile cases, at least 2 examinations or more were actually performed to make a determination of death, and so they far exceeded the minimum standard that's required to make a determination of neurologic death. It's important, though, that these second opinions are sought from experts in the medical field, because families may actually seek additional opinions from someone they have read about or a referral from a family friend. And many times because this happens because the family's looking for a different answer. And the experts that they may be soliciting may not be experts in the area of, for instance, neurologic death or neurologic diseases. The different answer or diagnosis rendered by another consultant doesn't mean the initial providers were wrong, but it can clearly create that sense for the family as they perceive that they found a physician who can provide them with the answers that they are looking for. And from that standpoint, it does create conflict because the family then loses trust in the medical team. Helping the medical team is important because we still have to care for the patient, and this is where involving the ethics committee can be beneficial, because the ethics committee helps validate that a plan of action or a course of treatment is reasonable. They can't tell you what to do, but they validate that plan of action, and that becomes really important. It knows that everybody's on the right track. Involvement in hospital leadership, which includes administration, risk management, unit leadership, family relations, and public relations, because public relations, as this gets out in the media, they have to work on damage control and provide a consistent message to the media while recognizing the difficult situation that the family is in and the fact that the family has a loved one that is dying or has died. And then importantly, we have to provide support for the emotional and the moral distress for our care providers, and this is really paramount, because if we don't take care of our providers, they can't take care of the patients. That leads us to really the escalation plan, and in all of this, I think these difficult cases are a call to action for the medical team in the hospital, because the best escalation plan is really a plan to de-escalate things, and the situation in these instances may actually be resolved, or some or all of the conflict may actually be resolved and go away. Alex has already said this. It's important to review your hospital policies and procedures about continuing somatic support for a decedent and how long medical therapies will be continued. Some of them say for a reasonable period of time. What's a reasonable period of time? What is reasonable for one person is completely unreasonable for somebody else. And so you need to review that, and it should be stipulated whether it's 12 hours, 24 hours, 48 hours, 72 hours. There needs to be a finite period of time. Additionally, the institution should really have a plan on how they want to deal with these conflicts before they escalate. So we want to be really proactive instead of reactive. And some institutions actually have an escalation plan. We had developed an escalation plan when I was working at Wake Forest. And the goal there was to remove the medical team from the center of this conflict and allow them to continue to provide ongoing medical care while supporting the family. And this response team, if you will, was composed of hospital and unit administration, risk management, legal, and hospital community relations and public relations. We reviewed the hospital policy, and it would escalate to a second, sometimes a third or a fourth opinion to help the family better understand the condition of their loved one. And if it escalated to the top level, then supportive administration to intervene and have those difficult conversations with the family while being supportive of the family was crucial, because what it did is it took the medical team out of the middle of that and allowed them to continue to care for the patient and the family, which is our primary goal to begin with. And that's important because although these conversations are difficult for the administration, they're the ones that should really be dealing with this. The problem that we get into is that these difficult situations, if left untreated, and if we don't support the staff, this is what results in burnout, because the staff has to deal with hostile families while they're trying to provide the best quality care for the patient and the families. And that results in a no-win situation. So I would encourage you to think about how you're going to handle this situation when it comes to your institution, because it will come to your institution at some point or another, and I just encourage you to be prepared for that.
And I think to wrap it up, we know that ultimately, even with the best tools and strategies, we can't eliminate these difficult cases or the conflicts that arise, both on the legal and the medical front, but that putting these strategies in place in advance is helpful to reducing the conflict or potentially being able to resolve it before it's full-blown and potentially in a court. We haven't talked that much about how this interacts with organ donation discussion. I think there's wide agreement that resolution of a death diagnosis has to happen first before there's going to be any organ donation discussions, for a number of reasons, including the potential for a good outcome on organ donation, which we know is dependent upon the family understanding that the death has occurred. And I think, though, as an OPO and having worked through some of these cases with our partner hospitals, the OPO, although in the background, the referrals should still have been made. The OPO can act as a really good resource for the hospital team, including the administrative team that's going to step in an escalation protocol, to understanding the intricacies of the applicable state law on death determination, as well as the medical standards for neurologic criteria, and just, again, act as a resource for the hospital in helping to navigate all of this. But ultimately reminding the hospital that if they're able to get through this conflict and there is a medical opportunity for organ donation, that approach needs to be made once the conflict is resolved, but before any of the ventilator support is removed, so that opportunity does remain. We have actually seen cases that have started out quite ugly with a conflict over a death diagnosis based on neurologic criteria result in a successful organ donation. It's rare, but it can happen, and so it is an important component of what the OPO can do in the background to help the care team at the hospital, but also ensure that opportunity remains if, in fact, it's one that exists in the first instance and is ultimately of interest to the family if the conflict over the diagnosis is successfully resolved. So I think with that, we just want to thank everybody for being part of this webinar, and all the work that you all do to save lives through donation and transplantation. And I know that we have a little bit of time for questions.
I think there's a couple of questions in the queue there.
So first and foremost, thank you, Alex, and thank you, Dr. Nakagawa, for such an informative and comprehensive discussion on the various aspects of end of life. As we go ahead and transition into our Q&A discussion, I'd just like to remind everyone that if you do have any questions for our presenters, please be sure to submit them using that chat feature. As a reminder, that's going to be located in the bottom left-hand corner of your screen. Additionally, during the Q&A session, I will have this poll up. So for those of you who are listening in a group, please complete this poll and let us know how many people are participating in your specific group. And with that, I'll go ahead and turn it back to Ann to moderate your questions. Thank you.
Thank you very much. So there are some questions out there, and I think both of you addressed this first question, but you may want to elaborate a little bit. The question is, if a hospital has a policy to accommodate for the family, say 48 to 72 hours post-declaration, does the patient's insurance stop paying the hospital bills? And how can we navigate having the ICU's palliative care stay away from focusing on deceding vent treatment?
Yeah, I'd be happy to answer that. So in general, insurance potentially could stop paying. It does depend a little bit on how the insurance is structured. An exception is New Jersey, which put right into its state law, together with the exception for religious accommodation, a prohibition against insurance companies from denying payment for the extra care time that is required for families to avail themselves of that religious exception. So if you're in New Jersey, insurance is going to pay. Otherwise, it depends a little bit, because if it's a DRG-based payment, the extra day or so may or may not matter. But in general, it's not considered necessary care to keep a decedent on support. So insurance would not be in play. I think that it is complicated to work with the care team to remind them that while they're moving towards having the family accept the fact that the patient has died and that support will be removed, at the same time the support won't be removed until the opportunity for donation, again, if one exists, is discussed at the right time. So there's not an easy formula to that, but having the OPO be involved, again, in the background should ensure that there's some coordination of a plan on how that's going to be handled, and a continual assessment of that medical suitability, which may or may not be there. So certainly, if it turns out organ donation is a remote possibility, it might lead, towards a different path than if it's a viable potential donor.
Great. Thank you, Alex. Also, introducing palliative care early is the new thought. Do you think introducing death as an outcome diminishes hope?
So palliative care plays a very important part in end-of-life care, and more and more intensivists are engaging palliative care specialists because we found that it really helps offload a lot of the conversations that the critical care team may be uncomfortable having with these families. So involving them is always a good thing. The discussion about death diminishing hope, I will tell you that I think my job as a physician is to prepare any patient for what lies ahead with any type of a diagnosis. And as an intensive care specialist, obviously, what lies ahead. If your child is sick, what do we expect? What is the pathway that we're going to walk down? And if we deviate from that pathway, where are we going to go? I will be the first to tell parents in these discussions about a critically ill patient who may die that realistically they may die. I am not a pessimist. I don't think it takes away hope. But I think we have to be realistic with those families, because if we're not realistic and if we don't cross that bridge, when we do cross the bridge, it's too late, and that's, I think, where a lot of this conflict comes about. I will tell you that many times as I've sat with families and talked about the fact that their loved one may not survive, that they may die from this injury, families will come back and say, well, if my child, in this particular instance, because I do pediatrics, if my child's going to die, I want them to become a donor. Well, I think that's wonderful, but let's focus on trying to restore your child's health. And if we can't do that, when we get to that point, we'll have those discussions. So I think it's up to us as the medical profession to focus on the fact that, yes, we're trying to restore health, but the reality is your loved one may die. Does that take away hope? No. I tell parents all the time, I'm not here to take away hope. I want you to hope. I want you to pray. But you have to have realistic expectations, too. This is a severe injury that's life-threatening.
Thank you so much, Dr. Nakagawa. Are there any tips for conflict when a patient is registered but patient's not brain dead and is a potential DCD candidate?
Yes, and actually I think there's going to be a whole webinar on that later in the spring. It is really a different circumstance, so that's I'm not sure if the question is any tips for handling the conflict about moving forward with donation when it's a registered donor and the family's objecting, or when the family has a conflict over the care team's diagnosis or prognosis that it's an unsurvivable brain injury and with withdrawal of support is indicated. And those are really different questions. If it's in regard to how to move forward over family objection when it's a registered donor, definitely going to be addressing that in a future webinar. And I guess to preview that, I think I would leave you all with this thought, which is that registering as a donor means that you've agreed to be a donor after death regardless of how death has been declared, whether that declaration is based on neurologic criteria or cessation of circulatory function following a withdrawal of the ventilator support, which would be the DCD circumstance. So I think that there's some clarity in the law, which doesn't make the cases easy, but it does remove the legal issue if you're talking about the conflict of a registered donor in a DCD circumstance and a family objecting. If the family is objecting to the withdrawal of support, as the surrogate decision makers, they hold that ability in most states, and so in that kind of circumstance, a DCD is not going to be able to move forward if the withdrawal is not going to take place. So that's sort of a short answer.
Thank you, Alex. We've reached the top of the hour. I was going to turn this back over to Deanna, and there are several questions left in the queue. Can we record those online?
Yes, so to those of you who are still submitting your questions, what we'll do is we will send them over to our presenters and give them some time to address those questions, and then we will send out the responses to all of you that have registered here today. So you will get your responses, but it'll be a little bit delayed just given that we are past the top of the hour here. So that being said, I would like to go ahead and conclude today's webinar. So once again, thank you, Dr. Nakagawa and Alex, for joining us today to share your insight on what I think is such a significant topic in transitionary period for families of potential donors. So thank you both. And also thank you to Anne for your efforts in facilitating today's discussion. We sincerely appreciate everything you all have done today. To all of our participants, we appreciate your participation, and we wish you a wonderful rest of your day. Take care.